Association would like to acknowledge the traditional, ancestral, unceded territory of the Coast Salish, Duwamish, and Suquamish nations on which we work and live. Just a couple of standard housekeeping items. We're going to go ahead and keep all of our participants on mute today. Cuts down a little bit on the sounds of our dishes and our dogs, but we will be recording today's presentation, so no worries if you don't get all your notes down in time. We'll be sharing that recording as well as our presenter slides in a follow-up email. If any questions come up for you, please feel free to drop those into the chat box or use the Q&A feature. I'll be monitoring both of those during the presentation, and I'll try and share them with our speaker as they come in, and we'll try to tackle as many questions as possible. If you're a little on the shy side, please feel free to directly message your question to me or Nancy or Elizabeth, and we'll make sure to keep your identity secret. And don't worry if you haven't quite figured out exactly how to word your question, or if it's something super specific to your own needs. We'll make sure you have contact information for myself and for our speaker, and we'll make sure that we get answers out to you at a later time. If this is your first time joining us, welcome. We're so happy to have you. Just a little bit of a background about People's Memorial, which is who I work for. My name is Beverly, and I'm the Communications Manager over at People's Memorial Association. We're the oldest and largest memorial society in the U.S., and we were founded in 1939 right here in Seattle. We're the only nonprofit in Washington that provides funeral education and consumer advocacy services. But if you're joining us from out of state, don't worry. We're one of about 73 organizations around the country under the umbrella of the Funeral Consumers Alliance, and I bet there's another organization doing some similar work a little closer to your own home. To date, over 215,000 people have become members of PMA, and of those folks, about 71,000 of them are living currently, so we stay pretty busy on a day-to-day basis. When we think about serving those members, there's a couple of primary functions we fulfill. One of the biggest ones is education. Classes just like this and a whole bevy of resources we host on our website just to make sure people can get access to that information at any time. We also are pretty big into a little bit of state-level legislative lobbying. We work to support our state legislature in increasing funeral choice. We work really hard to increase price transparency in a notoriously opaque industry, the funeral industry. And we're also really committed to protecting cultural rights. We're really blessed here in Washington to have an incredible diversity of people, and they all have different traditions and different needs and different resources at hand, and all of those folks deserve access to affordable and dignified funeral care, whether it be cremation or burial or aquamation or even natural organic reduction. Just saw a message come up real quick. Well, let me just check that. Oh, okay, I'll come back to that. Okay, so we wouldn't be bringing this series to you without the help of our good friend Nancy Sloat over at Seattle Public Library. Nancy, would you like to go ahead and say a little something?
Hi, Beverly. Thank you so much. And good afternoon, everyone. And welcome to our third program in our Ducks in a Row series. As Beverly mentioned, the other two programs on have already been recorded, and you can find them on the People's Memorial Association website. So I work with many great organizations like People's Memorial Association to partner on programs. And of course, the library has many programs and services for adults in general, but my focus is to make sure we have programs of particular interest to older adults and their families and friends, and how can we at the library support the work of the many great organizations, community organizations, other nonprofits, educational institutions, government agencies, which are working to make Seattle an age-friendly city. So one program that we have coming up soon is actually, I think, close of interest to a lot of people. It's vaccine transportation resources. The opportunity to do this program literally just came up 2 weeks ago. It's so new that it's not even in our online calendar. So you're the first to know, Tuesday, May 4th at 2 p.m. And so please spread the word for those individuals who may need sort of some transportation options to get to vaccination sites. You can check back for more details on that program and all of the other programs and services we have on the Seattle Public Library website. We have special places for the programs that I've been putting together. It's called Next Chapter, and I will drop that URL and website into the chat box. Just so you know, fair warning, at the end of today's program, I'm going to post a link to a survey. We really do appreciate the feedback, and it should only take a few minutes. It's in SurveyMonkey. And then finally, if anyone wants to contact me to talk about programs and services, or if you have general questions about the library, please get in touch with me and I will put my email into the chat and I'd be delighted to talk with you. So on that, I want to turn this back to Beverly.
Wonderful. Thank you so much, Nancy. Yeah, we've really enjoyed providing this series. It's been a couple months since we've offered it, and we love teaming up with SPL to do so. And don't worry if you missed the earlier sessions in the series. We're going to go ahead and have those recordings up on our website as well as on our YouTube channel. So don't worry. We promise this will all be available very soon for you. I'm also really excited. If you've been to any of our presentations in the past, maybe you participated in Green Funerals Week last year, an entire educational series that goes on for a week, just focusing on different aspects of green funerals, which is kind of a hot topic. And we're really excited to bring it to life again this year. We've decided to hold it in May. So if that's something you might be interested in, I would strongly suggest visiting our website and getting signed up for our programming newsletter so that you can get all those hot updates from me, and I'll make sure you have the dates for those sessions. We're so excited to bring this program back to life again. This was a wonderful success last year. Well, I'm very excited to welcome Elizabeth Jennings back. She is joining us from Northwest Elder Law Group, and she's one of my favorite presenters to work with. She is just a whiz at estate planning, and there's no question you can ask her. I think that would stump her. Welcome back, Elizabeth.
Hello, thanks for having me. Please don't try to stump me.
Good point. Okay, good point.
Try to answer as many of your questions as I can. So let me get this kind of sorted out here. But when it comes to estate planning, there's a lot, and I realize we only have a little bit of time here together. So today I just want to give you kind of an overview, things you should start thinking about if you've never done any estate planning, or maybe it's been a decade or two, but also things if you have done estate planning previously, or you've got these documents somewhere in a file and you have no idea what they are, what they mean after you read them or prepared them years ago. Now's a really good opportunity to kind of pull those out, take a look, make sure that they still make sense for your life. So I'm going to go over kind of some basic estate planning that applies to a lot of people, but I want you to keep in mind that everyone's situation is different. So this will kind of start the process, but know that your estate plan can be perfectly tailored for you, your situation, your family, your loved ones, your assets, but hopefully this will kind of get the ball rolling. So when I talk about estate planning and present about estate planning, I tend to think about it in kind of three big categories. What most people think about is planning for death, right? Nothing like a sunny Monday morning to talk about death, but that's what a lot of people think when it comes to estate planning. So we're going to talk about some options if you pass away, how to pass on wealth or provide for loved ones. But equally as important, some would say even more so important, is planning for periods of incapacity, right? If you can't make your own decisions, how do we put a plan in place so that someone you trust can step in and make those decisions on your behalf? And then lastly, planning to live a long time, right? Hopefully we retire, we've got enough assets, we can live the retirement that we've all wanted. and be able to provide for our needs, provide for a potential increase in care level that may be needed, and potentially also pass on something to our loved ones when we're gone. So that's how I'm generally going to organize my presentation today. I'll kind of stop at the end of each segment and see if there are any questions, but I also will answer questions at the end as well. So to start us off, talking about death and planning for death. So people often think about a will or kind of what happens to your stuff when you pass away. But I also like to think about it in terms of gifting, right? Being able to hopefully give something to the next generation or to individuals or causes that you care about, even after you've passed away. So when it comes to estate planning and estate planning tools, I'm going to talk about probate versus non-probate assets, kind of what you own and how you can gift it. And then some common kind of legal documents or tools to pass on your wealth when you pass away. And that doesn't mean that you have to be rich in order to do estate planning. It is something that I think is important for everyone, no matter the size of your estate. And it can also make things a lot easier for those that are left behind. So when we talk about estate planning, it can really be providing for whoever is important to you, and whether that's gifting or even maintaining some control even after you've passed away. So a lot of tools to do that. When I talk about someone's estate, I'm talking about what you own. And we all probably think, oh, I know exactly what I own. But you should keep in mind, especially if you are married, that your estate can sometimes be a little bit more complex. So if you are a single person, unmarried, everything you own is your estate. If you are a married individual, it's any separate property that you have, which can be assets that you inherited or were gifted or that you owned prior to marriage and have kept separate, as well as half of the community property that you own with your spouse. So in Washington, we're a community property state in the absence of something like a prenuptial agreement. What you acquire generally during your marriage is community property. So at death, one half of the spouses can gift up to half of their community property as part of their estate planning. So important to kind of keep that in mind. When we talk about our property, you can also divide it into probate assets and non-probate assets. So when I talk about probate assets, I'm talking about things that you own that don't have a designated pay on death beneficiary. So you may have bank accounts that you have already designated a pay on death beneficiary or a joint owner with right of survivorship. That's not what I'm talking about with probate assets. Probate assets are those that there is no one predestined to inherit that by operation of the document itself. And those probate assets are going to be governed by your will, if you have one, or by kind of the default statutes in the state of Washington. If you don't have a will, our state laws say, here's what we think you would want to happen with your estate. And you're going to have to follow those rules. So if you want to depart at all from the default rules, important to have a will or some other estate plan in place. Non-probate assets, as I started to talk about, those are going to pass according to those beneficiary designations. So again, pay on death bank accounts, maybe your 401k has a designated beneficiary, maybe you co-own property, joint tenants with right of survivorship. All of those are considered non-probate assets that transfer kind of outside of your will without the need of the will itself. So it's a way to kind of bypass the court process of probate, a way to bypass having everything pass through your probate estate. So important, I usually recommend to my clients every year, every couple of years, take a look at what your assets are. Are they a non-probate asset? Are they a probate asset? You know, how have you already provided for how these are going to pass at time of death? So that's one thing you could do without really hiring an attorney, doing formal estate planning. You can probably do from your computer at home, kind of look at your accounts, assets that you own. Have you designated someone to inherit those by default? That's going to be a non-probate asset. You can usually update those pretty easily online or with some documents that you would provide to your financial institution. I also get a lot of questions from people saying, I need to make sure everything I own is a non-probate asset because probate is the worst. And I'm here to tell you it's not the worst thing in the world to have your estate probated. Some states are worse than others. If you ever watch Susie Orman, she is all about having a revocable living trust because you need to avoid probate. Well, she's located in California. California has a long, expensive probate process. Washington has a pretty quick, efficient probate process, assuming your affairs are generally in order. So all probate is a kind of court oversight of the process of administering someone's estate. So the court will appoint a personal representative, also known as an executor, and they're the person that has to or gets to handle your affairs when you pass away, right? Make sure your final creditors are paid, make sure the IRS is happy, and then make sure that whatever is left gets distributed to your beneficiaries in the way that you've expressed in your will or other estate planning documents. So when I get calls from people saying I need to do everything to avoid probate, I usually try to calm their fears just a little bit. It really can be a quick and efficient process. It can drag on for years. It really just depends how much planning has been put into your estate planning and kind of the complexity of your assets and oftentimes family dynamics. So now that we've kind of got an overview of what's in your estate, right? The assets that we're talking about, I want to talk about some common estate planning documents or tools that people use. This first one, community property agreements or community survivorship agreements, these are an estate planning tool that is reserved just for spouses, legal spouses. And it's an estate planning tool. It's a document that can help alleviate the need for any sort of probate when the first spouse passes away. So this can be a really helpful, efficient tool for a married couple that wants to make sure that their spouse who survives them receives everything in their estate. And a community property agreement is just like a contract between spouses. Both of them sign it and say, look, everything I own, whether it's separate or community, let's consider it community at my death and transfer it automatically to my spouse. So again, in most instances, it's a way to completely avoid the need for a will or probate at the death of the first spouse. I always caution people though, please also do a will or some other estate planning. Don't just rely on a community property agreement because you never know who's going to pass away first. And it only operates when your spouse outlives you. It's also not always a good option for individuals that maybe one spouse is anticipated to have a lot of kind of expensive care needs as they get older. Maybe they may need to qualify for long-term care through the government. It may also not be a good solution if you have a large estate between you and your spouse. There are some ways to make sure that estate taxes are not going to be triggered if we kind of put a plan in place between the two spouses. So a good option to kind of keep in mind, they're usually short, sweet, maybe 2-page documents that can be really, really helpful between a married couple.
Good question.
For anyone. Oh,
So
sorry, say that again.
one of the participants has a question. Speaking of property between spouses, if there's an asset that's jointly owned with an ex-spouse, would it go to the ex with a survivorship deed, or is it possible to name someone else in a will?
It depends on the asset. So there are some assets that maybe, if they were an ex-spouse and the assets weren't addressed in like dissolution or divorce paperwork, it can get a little messy. It's important to look at how the asset is owned, and do you retain some authority to dispose of that asset when you pass away? So, for example, if you co-owned real estate with someone, you have to look, are you owners as tenants in common? Which means you each have an independent kind of share or interest that you can dispose of according to your will. Or are you joint tenants with right of survivorship, which means that of the co-owners, whoever outlives the other gets everything. So figuring out how you co-own those assets with an ex-spouse or with a third party, really important to figure out kind of, can you control where that goes at your death?
Good to know. Thank you so much.
So for most people, a last will and testament is kind of the default that we think about when it comes to estate planning. And a will, under Washington requirements, kind of any adult, so 18 years of age or older, of sound mind, can make a will. To be of sound mind, you have to generally kind of know who you are, know who the natural objects of your bounty are. That's kind of the fancy legal term to say, can you identify your friends or your family and who you want to gift to? And then, do you intend that document to be a will to pass on your assets at death? A will can cover everything you own or just certain assets, but at its very basic level, it has to be in writing, signed by the testator, the person making the will, in front of 2 witnesses, ideally disinterested witnesses, right? That can add a lot of complexity if you have, the only beneficiaries to your estate are the witnesses. It starts to look a little questionable. And then we also look that you want to have a self-proving will, that in addition to the witnesses signing the will, that they witnessed you sign it, you appeared to be of sound mind, they can also prepare kind of a sworn affidavit that recounts the situation, that they saw you expressed that this was your will, you weren't under duress. That self-proving will alleviate the need to go hunt down those witnesses and have them provide a written statement or testimony at the time that will is going to be admitted to probate. So something I would say to check if you did a will decades ago, see if there's a separate sheet or a page attached that says affidavit or declaration that your witness is signed as well. Wills can really be tailored to whatever you want. There are some basic components I'll talk about, but you can also build a lot into those wills to tailor your particular needs. At the very basic level, the will should identify who you are, and it should also identify your immediate family. Even if you don't want to give anything to your family members, it can be really helpful to at least identify them. That helps prove that you have testamentary capacity, right? That you at least know who the natural objects of your bounty are, even if you're not going to provide for them. Your will should also revoke any prior wills that you may have done or any codicils. Codicils are just a fun word, which is an amendment to a will. What's really nice about Washington is by statute, we also have a way that you can gift personal property to particular people, whether or not you include those gifts in your will. So what this RCW, the Revised Code of Washington provision says, is that if you reference in your will or estate planning documents that you may keep a separate list to gift your tangible personal property, then you can maintain and update and change that list without having to change your will. So this is kind of a way to formalize what my grandmother did with my mother and her sisters. She gave everyone a different color Post-it note and said, put the Post-it notes on what you want in the house, right? This is a way for someone to maintain a list. They can type, they can handwrite of particular items, jewelry, furniture, sentimental items, and who they want them to go to. And it's a list that you can sign and date and update without having to change your will, just something you can keep with your will. Your will, when it comes to gifting, can also give specific items to specific people. So you could say, I give $500 to People's Memorial. I give my car to my niece. You can give specific things or specific dollar amounts to particular individuals or organizations or classes of people. And then your will should also have what's often called a remainder or residue or residuary clause that basically says everything that's left after all my debts are paid and my specific bequests are given, here's who gets everything else. So that could be everything to one person, that could be percentages to multiple people, but that way it's kind of a catch-all, who gets whatever is left. And you can even build in alternates, right? So if I said I give everything to my husband, but if my husband is not alive, right, if he predeceases me, I give everything to my child. So that's what's kind of nice, a well-written will, you can build in a lot of kind of catastrophic scenarios without having to constantly update your will as kind of things change.
When you think about building those conditions in, could you say a little bit about how you might build some limitations into it? One of our participants was kind of curious, like, can you maybe delay an inheritance to a kid that maybe isn't so money wise or something like that?
Yes. Give me one more slide. We are going to talk about that. Those are typically going to be trusts, or we'll talk about like UTMA accounts. But yes, there's a way that you can control a lot even after you've passed away. So
perfect. All right, thank you. Get back to it.
So besides kind of who gets what, a will also or should also identify a personal representative, same thing as an executor. But who do you trust to carry out your wishes in your will? And again, you can build in a lot of alternates, right? So my husband is my personal representative, but if he passes away before me, I name my brother. You'll also see that nomination of the personal representative will usually include a grant of non-intervention powers and waiver of bond. So that means that you want that person to be able to carry out your wishes without having to keep going back to court to get permission for certain actions. So again, that's one of the tools in Washington to make probate pretty efficient, is if you grant non-intervention powers to your personal representative. The testator, the person making the will, has got to sign it, date it. The witnesses will sign the will that they witnessed the testator sign the will. Again, that affidavit of attesting witnesses, kind of a second sworn statement proving that they were there and that you had that testamentary capacity. So those are kind of the basic elements. But then from there, we can get even more creative. So if you have minors, right, if you have children, you can designate in your will who you want to be the guardian of those children, right? If there's no surviving parent, who do you want to look after your children, have custody over your children, and care for them? And then related back to that question earlier, you can also have trusts within your will. So if there is a beneficiary that you want to gift to or you want to provide for, but maybe you don't want them to have all that money at once, a trust is a really good option to kind of figure out how can we tie up that inheritance or put some limitations on that inheritance. So testamentary trust can come in every shape or form. And so I would say this is something, if you are considering incorporating a trust into your estate plan, it's worth consulting with an attorney who deals with trusts. But trusts are an estate planning tool that can be used within a will or separate from a will. And it's just an arrangement where one person or entity is holding on to assets for the benefit of another person. So it can be for the benefit of minor children. It can be for the benefit of a individual who you think is going to blow all the money within 24 hours. And there can be some really good reasons to put assets into a trust instead of gift to that person outright. So we commonly recommend trusts if maybe there is a beneficiary who is 5 years old right now, and they can't legally inherit until they turn 18. But I don't know a lot of 18-year-olds that I would want to get a big chunk of money on their 18th birthday. So maybe we want to tie up those funds until their 20s or till they've graduated from college or till they're 60, whatever it may be. But a trust structure is one where you give a trustee the authority to manage that property for the benefit of a beneficiary, of someone else. So trusts are super helpful for minors, but keep in mind that instead of putting assets in a trust for minors, Washington also has what's called the Uniform Transfers to Minor Act law. And that provides that when you are giving to someone either under age 18 or even up to age 25, you can specify that instead of them receiving those funds outright at a particular age, they go into a UTMA account where a custodian, like a parent, will be able to spend for that child's benefit out of that account until they turn a particular age. And it maxes out at age 25, but it's kind of a good alternative to a trust when we're dealing with gifts to a minor. You can also set up trusts when you want to gift to someone who's not good with money, doesn't make good money choices. Maybe they have some incapacity issues and they really can't manage those funds by themselves. Or if you have a beneficiary that's currently receiving needs-based government benefits, right? If they are on Medicaid, for example, and they get a huge influx of cash, they're going to be disqualified from that program. So there's a way you can build into your estate plan like a special needs trust for a beneficiary, that those funds are available for their benefit, but it won't disqualify them from receiving the government benefits that they're on. Trust can also, go for it.
I'm sorry. We have a question about like maybe the limitations of trusts. Is there any limitation about including assets across country lines? Is there anything special with that?
Ooh, so assets located in other countries or benefits or beneficiaries in other countries, depending on how it's structured, it can get a little bit tricky. So that's something I would definitely say consult with an estate planning attorney on. There can be certain limitations as far as how much can be transferred to a beneficiary of another country, what it's used for. So that's where you start to get into some tricky situations.
Okay, so trusts do have some limitations,
Yeah,
so they don't solve the
but
problem.
I would say you just, because they can be crafted for kind of any scenario, you just have to be very careful about what other laws may kind of limit what you can and can't do with trusts.
That makes a lot of sense. Okay, thank you.
So there are lots and lots of types of trusts. I'm not going to talk about these in any sort of detail, but know that trusts come in every shape or form. So when I get a call from a client saying, I need a trust, right? I start to say, what kind, right? What's the goal? What's the purpose? So start to think about that. If a trust arrangement is something that appeals to you, who do you want to provide for? What kind of limitations do you want to put in there? And what's the goal, right? Sometimes these trusts are necessary to avoid or limit estate taxes. Sometimes they're to protect the beneficiaries. Sometimes it's helpful, like in a blended family situation. Maybe you have a beloved pet that you want to provide for, but you can't give your dog Fido $1 million. You need to establish some sort of pet trust. So lots of different trusts. Just, again, we cannot go through them all, but there are options there.
I have another question about trusts for you. One of the participants wants to know how long can a trust exist? Maybe if you're planning for the care of your dog for a long period of time, what are the limitations on that?
Yes, so there are limits. Great movie, a George Clooney movie. Now I can't remember the name of it. The Descendants. It's about the rules of perpetuity. So there are these rules about how long a trust can go on. They differ a little bit by state, but generally a trust cannot exceed kind of the lifetime of, I guess, it can't exist for multiple lifetimes of individuals. So you can tie it up maybe for your children, your grandchildren from there, but you can't tie up these assets for centuries to come. The government says, hey, we want eventually to break up some of this wealth. But you can have trusts that maybe provide for grandchildren that maybe aren't even alive yet. But unless you've got millions and millions and millions of dollars to try to tie up those assets for centuries, it's probably going to have to terminate within, the lifetime of someone alive or who's going to be come into being at one point. It was a really complex way to explain the rule against perpetuities. It's a fun one.
Okay.
You also hear a lot about revocable living trusts. Again, that's one of the favorites of Susie Orman. And a revocable living trust is a trust that you create and can put assets in while you're alive. So you can be the creator of the trust, you can be the trustee of the trust, and you can be the beneficiary of the trust during your lifetime. So this is something I may recommend to clients if they have a really strong desire to avoid probate, or they have real estate in several different states, right? They don't want to have to go through probate in multiple different states. Maybe they have a blended family and they want to provide for their spouse, but also make sure that their children are taken care of. So there can be some good reasons to have a revocable living trust. It's just not something I usually recommend for everyone right off the bat. Totally depends. I'll take some questions on estate planning in a moment. I just wanted to also mention estate tax. So people always say, I don't want the state or the government to get anything. And there are some pretty high tax rates when we are gifting at death. But there are exemptions. So in Washington state, our exemption amount for 2021 is $2,193,000, or million, 2 million, there we go, that you can gift to anyone without estate taxes. It's only for amounts over that estate tax may be due. And gifts that you make to your spouse, those are exempt. You can give everything to your spouse without estate taxes. There's also exemptions for charities and some political organizations. So again, for a lot of people, maybe estate tax planning isn't a huge deal, especially at the federal level. I forgot to update the 2021 federal exemption amount is 11.7 million. So again, you can give a lot of your assets without estate taxes being an issue. But if you are an individual that your estate is getting, up and over that $2.193 million threshold, that's where estate planning with some tax considerations can be really important. And we also never know what government is going to do, right? They could always change the exemption amounts, create new rules. So it's a really good excuse to just keep an eye on your assets every year or two, check in, make sure the laws haven't changed too substantially.
I'm sorry, just a quick question about that limit you mentioned. I've never seen anyone ask this question before, and it's a really good one. When we're looking at those limits, is that counted for the estate as a whole, or is that limit set per person that's a beneficiary of those assets?
The estate as a whole. So basically the government takes a snapshot of everything you owned on your date of death, and that's what they're going to consider for tax purposes.
Okay, that's an important distinction.
Okay, so other estate planning questions before I jump into incapacity or disability.
Let me take a quick look and see what I can find for you. We got lots of good ones. How about, I know that we were saying there might be some complexity to moving assets across borders, but what if you just, it's something as simple as your executor lives in another country and they're a permanent resident of that country? Does the person that's the executor have to live where you live, or how does that work?
Good question. No, they don't have to live where you live. So an out of state or an out of country executor can still serve. But there are some limitations. So number one, if they're not located in the state where it's probated, they have to designate someone in the state to be their resident agent for like service of legal documents. So I may act as the resident agent for my clients that are personal representatives who live out of state. There can also be a little bit of an issue for personal representatives in another country, especially if the court imposes bond on a personal representative. That's something you can ask to waive in your will. But a lot of bonding companies may not bond someone who doesn't have assets in the United States. So that can be a little bit of an issue.
Makes sense. A clarifying question. So when we're thinking about who the state considers our family, if we don't have a spouse or a legal partner, would the state then consider our family to be our kids, or who's kind of next in the lineup?
Yeah, so if we look at the laws of intestacy, which are the statutes in place if you don't have a will or an estate plan, the state kind of assumes, okay, you want to gift to your spouse and your children. If you don't have a spouse, you want to give them all to your children. If you don't have a spouse or children, you want to give to your parents. If your parents aren't alive, you want to go to your siblings. If you don't have siblings or nieces or nephews, we kind of keep going out the family tree. So there, I have handled probates before where someone did not have a will, and long lost cousins that maybe they've never met before ended up inheriting their estate. So think about your immediate family. And if you don't have a lot of immediate family, it could be people that you don't even really know could inherit unless you put a will together.
There's a lot of value in writing down your wishes, it sounds like. Okay, well, some folks have some questions about kids, like if they were to name their son on a trust for the home that they own, would he be required to report that as an asset while they're still alive and living in that home?
So generally when a trust becomes irrevocable, or if if you put an asset into trust for the benefit of your son doesn't own that, but the trust is its own legal entity as well as its own entity to the IRS, right? So there can be higher tax rates for trusts than there are for individuals. So if there is an asset in trust that maybe isn't accumulating a lot of income, may not really have a big tax bill. So it wouldn't be included on the beneficiary's kind of taxes. But if there's an asset that generates a lot of income, the trust itself that holds that asset may end up having to file its own tax return and pay Uncle Sam.
Oh, holy cow. Well, is there maybe a circumstance, when you're doing all this contingency planning and trying to predict the future in a way, is there a way maybe that you could designate co-executors of your estate?
Yeah, so I usually say don't go beyond two, but you can designate two co-executors to work together to manage your estate. They can kind of divide and conquer, or you can require that both of them have to sign off on everything. But that's why I also like to recommend that you name backups, right? So if one of the people you named is no longer alive or just doesn't want to deal with it, have you named another co-executor that can act independently, or have you built in a couple of alternates to be able to take over, if one wants to step down or can't act? You can also name, it doesn't have to be a friend or family member. There are professional fiduciary organizations or companies that you can name that it's their job to handle all of these things for you. So they usually take a pay, usually by the hour. In some individual or some organizations will pay or get paid by, percentage of the assets under their care. But that's an option as well. If there's really not someone you trust in that role or that you want to put that responsibility on, you can name a professional to handle these things for you.
We have a couple folks who are kind of concerned, maybe I won't have friends or family around at the time that I can trust. Do you have any recommendations for ways that folks could identify a good agent to perform those tasks?
I would say number one, if you have, a lot of assets like investment assets, some brokerages, Edward Jones, Merrill Lynch, they may have a trust department where they will serve as professional fiduciaries. I also recommend, Googling professional fiduciary and your zip code. There are a lot in the, greater Seattle area. Some are nonprofit, some are for-profit. Most of them you can probably find Google reviews or Yelp reviews. You can interview them and kind of get more information. There are just a lot out there, some big, some small. So it's kind of important to do your research and make sure that it's an organization you're comfortable with.
Yeah, that can be pretty tough to dig through all those options. There's so many, it's a embarrassment of riches. Do you have any hot tips for questions to make sure you ask when maybe you're shopping around for folks?
I would say especially for smaller organizations, I recommend asking kind of what's their succession plan, right? You don't want to outlive the professional organization. So if it's just one person or one or two people, do they have a plan for kind of who would take over their accounts if they pass away? So that's where I see some people lean towards the longer or the larger organizations that have a lot of people that can kind of step in, and they have employees that can manage everything. But the risk is that the person maybe you interview is not there when it comes time for them to step in.
Well, we do have more questions, but I don't want to steal too much of your presentation time. So why don't you hop back on there and we'll see what we can tackle when you're done.
I know there's a lot. Remember, this is just to whet
I
your
warned you.
appetite.
They've got great questions, this group, I tell you.
Okay. Well, kind of shifting gears from planning for your death. It's planning for incapacity or disability, which, we don't like to think about this, but most people will experience either a temporary or permanent period where they lack the capacity to make their own decisions or manage their own affairs. So that's why I always talk to clients like, yeah, will's important, but you're dead when that has any sort of legal effect. So instead, you may want to consider a power of attorney, right? So a power of attorney is a document or a series of documents where you identify someone who gets to step in your shoes when it comes to financial transactions, healthcare decisions, particularly for periods where maybe you are temporarily or permanently incapacitated. It could be that you have dementia and are just unable to manage things yourself. Could be that you're undergoing a surgery and there may be a recovery period where you're on a lot of drugs, can't kind of make reasonable decisions yourself. I had a client at the beginning of COVID who had traveled internationally in the middle of trying to sell his house and got stuck due to country shutting down. And he had designated a power of attorney with immediately effective authority who was able to finish the real estate transaction for them. So powers of attorney can be a really helpful tool where you identify an agent to make decisions on your behalf. So that's all a power of attorney is. It's an agency relationship where you as the principal are saying, I trust this person to be able to act on my behalf, to step into my shoes. You can have a power of attorney that is for a limited time period or a limited purpose, like a particular real estate transaction. You can have a power of attorney for healthcare decisions and a different one for property or asset decisions. They are governed by statute in the state of Washington. So if you're curious to kind of read up on the bounds of powers of attorney, you can go to the revised Code of Washington, find it on our state legislature website. Title 11, Chapter 125 includes the requirements for a power of attorney, kind of the default powers for a power of attorney, limits that you can put on it. But it can be a very important document, again, for lifetime planning. So it can be very, very helpful. You can name a person, like a friend or a family member, a spouse. And again, you can also consider a professional. So if there's not a friend or family member that you want to appoint or that you can think of appointing, searching for those professional fiduciaries, again, through financial institutions, through organizations, companies, they will take on that role, be nominated as your power of attorney. As always, I like to say plan for the worst, but hope for the best. So I recommend building in alternatives into your power of attorney, right? Have backups, have 2 or 3 or 5 backups if you'd like. Because if there comes a period where you lack capacity, particularly for financial transactions, if you don't have a power of attorney in place, then a guardianship going through the court to have an appointed guardian may be necessary. Our state has kind of built in default rules for who can make medical decisions and give informed consent on your behalf if you don't have a power of attorney, but they haven't passed default rules for financial transactions. So that's where the power of attorney, super, super important. You have a lot of control in that power of attorney, how much authority you want to give your agent, and then how quickly you want them to have that authority. So you can have a power of attorney that is effective immediately, where you basically say, as soon as I sign this document, my designated agent can act. It's totally fine if I've got capacity, I can do whatever I want. I can go about my business, but I've also appointed maybe my spouse as my power of attorney or my child as a power of attorney who can jump in and help me if needed. The other option is that that power of attorney is springing, which means it only has effect if you are deemed incapacitated. So this can sometimes be a little bit tricky because you usually have to get a physician, your primary care physician or attending doctor, to put in writing that you are incapacitated, unable to manage your own affairs. So that may be kind of tricky to get. Some doctors may be hesitant to put that in writing. It can take some time. So in an emergency situation, maybe a little bit difficult to trigger that authority. So that's a conversation I tend to have with clients. Who are you naming? And do you trust them to have that authority immediately, whether or not you lack capacity? Powers of attorney do need to be in writing. They're signed by the maker, and either that signature needs to be notarized or it can be done in the presence of two witnesses. However, if that power of attorney is ever going to be used for a real estate transaction, most title companies want to see that it's notarized. So keep that in mind. As I mentioned, our state statute has kind of default authority. You can kind of read through the default powers that can go to an agent under a power of attorney, but you can also specifically list authority. And then there's also extra powers, kind of extraordinary powers you can decide to give your agent, right? Do you want your agent to be able to make gifts of your assets to other people? Do you want your agent to have the authority to change the pay on death beneficiary designations on accounts, right? You can give that person extraordinary power or kind of limited power depending on your particular comfort level. So some people may have a joint power of attorney that's got healthcare and financial decision-making. I tend to do two separate powers of attorney when I'm working with clients, one for healthcare, one for finances. There are people that I would trust to make financial decisions for me that maybe I don't think would be the best to make healthcare decisions for me. So financial powers of attorney can cover paying bills, accessing bank accounts, buying or selling real estate, but coordinating with your healthcare agents. But then you can have a separate power of attorney for healthcare decisions. So I tend to do two separate because they just operate in different scenarios. A healthcare power of attorney is, again, who do you designate to be able to stand in your shoes for purposes of making decisions about your medical treatment? If your physician can't get informed consent from you, who should they turn to? If you don't have a designated healthcare agent, we do have, again, a default statute in Washington, right? There's kind of an order of priority of who can step in and give informed consent on your behalf. So your spouse, adult children, your parents, your siblings. But if you don't want those people to be your designated agent, that's where it can be helpful to have a healthcare power of attorney in place. Okay, just see that the chat, the questions are looming. I'll take a couple.
Okay. Yeah, so we did just hit 3 o'clock. I think we tackle a couple questions, and then there's so many good ones in here, so many things I've never even heard before that I'll make sure to touch base with you, Elizabeth, to get some answers, and I'll include the responses in the follow-up email to the webinar so no one runs away without getting their questions answered. I think let's go ahead and focus on the document management side of things. So let's see, what have we got here? So there's been a ton of great suggestions in here for ways to sort of bulk up the planning for contingencies and all kinds of things. If folks already have a will and they'd like to incorporate some of these things you've suggested, do they need to start from scratch or can they amend their existing will?
You can amend your existing will through codicil, but it has to follow the same formalities as making a will in general. So you can't just cross stuff out and handwrite it in. That's going to invalidate that whole portion.
Really?
Any amendments still need to be signed and dated by you in front of 2 witnesses. So oftentimes it can be more efficient to just do a whole new will than to build a whole bunch of amendments. But it's a possibility, but just know handwriting changes, kind of doing your own amendments that aren't witnessed, that can be a problem.
Okay, that's good to know. So one person's curious to know about the, deciding between the notaries and the witnesses. When you sign your will with your own signature and you have a notary, do you not have to use the witnesses, or is it an option, or do you need all 3 folks?
For a will, you always need 2 witnesses.
Okay.
Just having a notarized will is not sufficient in Washington. You don't even need really a notary for a will. But for powers of attorney, a notary can be used instead of witnesses.
Oh, I'm going to do a plug here real quick. That is a benefit of PMA membership. So I know that a lot of institutions haven't been able to offer notary services because of COVID protocol, but I am a notary, and if you need that service, I'll make sure you have contact information for me in that follow-up email so we can get your documents taken care of. Okay, let's see what other questions we've got. Okay, so someone wants to know, would you recommend that a financial POA be guided by 2 doctor signatures, or 1, or immediate?
It really depends on your comfort level, who you are naming, and how many hoops you want your agent to have to jump through. I will tell you, my husband, I'll use him as an example. He's like, I just don't want 2 doctors. I want 3. I want 3 people to agree that I am incapacitated before someone else can step in. But that could be really difficult, right? He doesn't always listen to me. Because if I need to be able to act quickly, good luck getting 3 doctors to immediately put something in writing that you're incapacitated. Yeah, so it really depends kind of who you're naming. Do you trust them to act, would you trust them to act immediately? Then maybe you don't need to necessarily put those restrictions in place. Maybe you tell them, hey, if there's an emergency, I keep my power of attorney in my desk drawer. You're my agent. Go get it if there's a problem. And boom, they've got immediate authority when it's time. But again, maybe you're like my husband and want to make it Fort Knox before anyone can step in on your behalf. So it's up to you kind of what restrictions you want to put in place before that power of attorney takes effect.
That actually makes me wonder, though, is there, where should people keep these documents once they put all this work in? I feel like the inclination is to keep it under lock and key because there's lots of private information in there, but is that practical?
I usually say keep it somewhere where you keep your important papers. So some people say, oh, I keep it all in my safe deposit box. Well, someone's going to need to get into that safe deposit box in an emergency. Is there another signer on that box who has the key? If you're comfortable providing copies of these documents with your agents, I recommend that. We always retain a copy of signed documents internally at our office, but we give the originals to the client. So some may put it in a desk drawer, in a safe at their home, and let their family members know where to get it. I've had some clients that put it in a Ziploc bag in their freezer.
Heard that one.
Yeah, I guess that's a place where people think to look that may survive a fire, I guess. I don't know.
Kind of makes sense.
It's important to tell, whoever your designated agents are, tell them where to go find this stuff, right? Because I had a great uncle who was a little bit of a hoarder, and we didn't know if he had a will. We had to go through every book, every newspaper, every piece of paper that he collected over decades, couldn't find anything, right? So it's important to let the people know where to go find these documents if there's ever a need.
That makes a lot of sense. Okay, well, we're coming up on 3:10, and Nancy just dropped into the chat a survey for all of the participants. If you wouldn't mind completing it, they're just gathering a little bit of information for their programming. And I'm going to go ahead and save all these other questions in here because there's so much good stuff, and we'll make sure you get the answers to that. I don't want to hold you up when the weather is so lovely. We should all just be enjoying it. Thank you so much for joining us on a Monday and talking about estate planning, which, you know, isn't the most fun on a Monday, but it's so important, as we've learned today. Thank you so much again for joining us, Elizabeth, and sharing your expertise with us and fielding all those questions that are just gnawing away at the back of our minds. Nancy, do you have anything to say before we finish out today?
No, I just really appreciate your all coming, and I know Beverly will send out in a follow-up email answers to questions and links to the recordings and prior recordings. And just wanted to say that there is also a recording on just a whole program that we did on advanced care directives. So we'll put that link in there as well.
Absolutely. Yeah, no, we, all three of us, you know, our jobs are centered on getting people answers to the questions that are bothering them. And so don't hesitate to reach out to us with those questions. That's what we're here for.
Great.
And I will put my contact information, and I know that that will go out in the emails as well. So feel free to give me a call or shoot me an email if you ever have questions. Sorry, I know I have it somewhere. There we go.
Wonderful. So there's that for you all. And yeah, we'll make sure that you get a copy of these slides as well to refer back to, contact information, a recording. And if you think of anything else that would be helpful to you as you sort of traverse this process of getting all your documents updated, just reach out. And if we don't know the answer at PMA, we'll connect you up to one of our friends like Elizabeth, who, you know, is going to be able to get you a little bit more of a detailed answer. Thank you everyone for joining us. And if have you, Elizabeth and Nancy, just stick around for a second after everyone leaves, we'll go ahead and be good to go for today. Thank you everyone so much for joining us.
Bye.